Okay, the court is on the record in City of Pontiac versus Amber R. McHenry, case number 24 TRD 527. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. We may have a resolution of the matter, should the court be willing to accept it, whereby the city would dismiss the fictitious plate charge at defendant's cost, and Ms. McHenry would then enter plead guilty to the two remaining charges of failure to reinstate driving under suspension and expired plates. The city would then recommend whatever fines the court would deem appropriate along with the court costs of the case. Thank you.
Thank you. Mr. Sayage.
Thank you, Your Honor. I did convey the offer from Law Director Lewis to my client, Ms. McHenry, after extensive talks and going over what she would be waiving today. She has decided today that she would take the plea offer along with the state's recommendation of just court costs and fines.
Okay, Ms. McHenry, it's my understanding today that you wish to change, you originally entered no plea to charges of failure to reinstate an unclassified misdemeanor and expired plates, a minor misdemeanor. You wish to enter guilty pleas to those two charges. In exchange for those guilty pleas, the fourth-degree misdemeanor charge of fictitious plates would be dismissed at your cost. Is that what you would like to see happen today?
I believe so.
You understand by pleading guilty to those charges that you would be waiving your right to the jury trial that is currently scheduled at the end of the month, as well as all of your trial rights. We just had a trial last week, so you kind of know what a trial is like. So by pleading guilty to these two charges, you'd be waiving all of those trial rights. Is that what you wish to do?
Would that put an end to litigation?
Yes, it would.
I mean, no.
I'm sorry?
Yes.
Okay. Also, you are represented by Mr. Sayage. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Okay. I do find that defendant's pleas of guilty to these minor and unclassified misdemeanor offenses in subcase A and B, failure to reinstate and expired plates, to be knowing, voluntary, and intelligent. The court will accept the guilty pleas to those two charges, and I will therefore find her guilty of those offenses. I will dismiss at the defendant's cost the fictitious plates charge in subcase.
Welcome back, everyone. Today's courtroom breakdown is a perfect example of what happens when internet legal theories collide headfirst with reality. We're looking at 3 separate cases involving individuals who walked into court convinced that the rules either didn't apply to them or could somehow be rewritten through a collection of misunderstood legal phrases, trust documents, and jurisdiction arguments. First, we'll revisit a familiar face who previously insisted the court had no authority over her, only to find herself accepting a plea deal after months of fighting. Then, we'll head to Georgia, where one of the most patient judges you'll ever see attempts to navigate through a maze of sovereign citizen-style arguments, trust claims, and legal buzzwords that sound impressive until they're examined for more than a few seconds. Finally, we'll watch a case where a litigant openly declares that state laws don't apply to her at all, a strategy that turns out exactly as well as you'd expect. The common thread in all of these hearings is the massive gap between what these individuals believe the law says and what the law actually says. Pay close attention to how the judges respond, because instead of getting angry or emotional, they methodically explain why these arguments fail. The results are equal parts fascinating, frustrating, and at times surprisingly entertaining. And trust me, some of the statements you're about to hear are so unbelievable that if they weren't recorded in an actual courtroom, most people wouldn't believe they had.
Ms. McHenry, I did not impose community work service. I could have. I did not impose a Class 7 license suspension. I could have on the failure to reinstate charge. I've just given you a fine and cost, although I'm ordering you to provide proof of insurance on the vehicle you're driving that day. If you're not able to provide to the clerk proof of insurance on the vehicle you're driving that day, you are subject to what we call a non-compliance suspension with the Bureau of Motor Vehicles. I guess what I'm saying is, Ms. Henry, I could have sentenced you in a much more severe way. I did not. But understand that if you're back here with similar offenses and you're found guilty of those, I will impose those. What I didn't do today, I would do at a later time.
This is one of those moments that perfectly demonstrates the difference between internet theories and real-world consequences. For months, this defendant challenged the court's authority, questioned jurisdiction, and fought the charges as though the entire legal system simply didn't apply to her. Yet here, we are watching a complete shift in strategy. Instead of continuing down that path, she's accepting responsibility and resolving the case through a plea agreement. Whether this represents a genuine change of heart or simply a practical decision to avoid greater penalties is impossible to know, but it highlights an important reality. Courtrooms operate on evidence, statutes, and established procedures, not on personal beliefs about how the law should work. What's particularly interesting is how much risk she avoided by reaching this resolution. The dismissal of one charge and the relatively limited penalties suggest that cooperation can often achieve better results than prolonged conflict. What do you think? Is this a sincere acknowledgement of reality, or merely a tactical retreat to bring the case to an end?
The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Delphine Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointed judge.
Ms. Turner, I got to see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right, so
Okay.
Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I'm only in this case because I filed an answer for Mr. Widener.
Intended to name me too.